Good morning, my friend. How are you today?
Doing great, doing absolutely fabulous.
Okay, so I'm just going to let you take it away.
All right, well, thanks, Linda. Hello, everyone. My name is Sean Scott. I'm what's known as an elder law attorney. What does that mean? Well, all the people I take care of are old, basically. All of my clients, they're deep in the aging process and they're running into problems that they never even imagined that they might have in the future. I don't know, I'm getting a little older now. My knees, my hips, things don't work quite as good as they used to. So now I'm going to the doctor, and the doctor says, "Hey, man, what's wrong with me?" And the doctor says, "Sean, you're getting old." Great. All right. Well, just like there's specific doctors that deal with your issues related to aging, there's also lawyers that deal with your issues related to aging. So as we get older, not only do we have different medical problems, but we also have different legal problems. And in my practice, I focus on those main things. I deal with incapacity, the ability to make sure you have somebody that can be a backup to you if you can't be you, powers of attorney, healthcare surrogates, those kinds of things. Incredibly important. We're going to talk a little bit about that today. And then there's this other issue, mortality. As we age, the whole idea, the mortality event, as I call it, we're all going to die at some point in time, and we can't take our stuff with us. So how does our stuff get to our heirs, the people that we want to have it? Who's going to be in charge? That's kind of estate planning. Lots of different ways of doing that. Kind of important that you have a plan in place. We may touch a little bit on that today. And then there's this third piece that I deal with, and that is issues of care. How do we take care of ourselves or our loved one as we or they age? Well, as you age, you're going to run into these different problems. Again, my knees, my hips, I'm not as good as I used to be. Well, what happens if my issues or your issues get to a point where you need somebody else to help you out? Whether it's a family member, maybe bringing in somebody into your home from a home care perspective, transitioning into an assisted living perspective, or even ultimately, because of the complexities of your needs and how much help you do require, that you transition or you move into a nursing home or a skilled nursing environment. Every time you go into a deeper level of care, the expense goes up. The expense, the cost. In the home situation, a lot of variables, maybe $3,000 a month, depending on how much care you're having provided in the home. You go into an assisted living, maybe 30,000, 3,500, up to around 7,000 is for memory-specific care in a place like Arden Courts, for example, which is a memory or dedicated memory care assisted living facility. And then if you transition into a nursing home environment, you're looking at $10,000 to $12,000 a month in our community. $10,000 to $12,000 a month, each and every month that you're there. Now, many of us could probably afford that for a couple of months, but if you multiply that over a year or multiple years, that math problem really equals financial devastation for you and your family. So one of the things that we do, that I've been doing actually for the last 35 years, is assist my clients get eligible for public benefits to pay for the cost of that care. There are several different public benefits that we work with, some places that we can draw money from in order to pay for the cost of this care. There's the PACE program, for example. There's the VA that has some options available. But the big one that we often turn to is a program called Medicaid. Medicaid with a D, not Medicare. Medicare, I think most of us know what that is. And basically, Medicare is health care for older people. Isn't that going to take care of me when I get older? Isn't that going to pay for my nursing home care? And the unfortunate answer is no, probably not. The Medicare side of the equation, that's a particular solution, will pay for a little bit of care under very specific circumstances. For example, if you're transitioning out of the hospital and you need to rehabilitate to get a little bit better, you're not ready to go home quite yet. So you want to rehabilitate, going to get you a little bit better so that you can finally transition to your home. Medicare is going to pay for you to do that rehabilitation inside of a nursing home. Awesome. The first 20 days, Medicare is going to pay 100% of the bill. That's pretty great. On day 21, you have about a $200 a day copay that has to come out of your bank account. Now, if you have a Medicare supplement insurance policy, a lot of times that Medicare supplement will pick up that copay. But if you don't, you're now on the hook for around $200 a day. Also, Medicare does not pay forever. Medicare, what they are, Medicare has a maximum coverage of 100 days. So once you get to day 101 in your stay in the nursing home, Medicare is done, they're no longer paying, and you go you go on to private pay. And private pay means taking your checkbook out and writing a check to the nursing home every month. Okay, is that awesome? I don't think so, not at $10,000 to $12,000 a month. So we need to figure out a new solution for that. Pretty much the only game in town from my perspective, if we're not paying out of our own pocket, we can't go rob a bank, for example. That's not a solution. Although I have joked that if you do rob a bank and you get caught, I guess your care will be paid for by the government, but it's in the new federal penitentiary and nursing home that they're building all around our country. So again, still a joke. If we look in all seriousness, though, we need to pivot and look towards Medicaid. Why are we looking at Medicaid? Isn't Medicaid for poor people? Well, technically, I guess it originally was created as healthcare for poor people. Back in late 1960s, under President Johnson's administration, President Johnson was trying to get healthcare for everybody in this country. But he was unable to do that due to a lot of political issues. And he was, however, able to salvage healthcare for old people. That's when Medicare was created. And he was also able to salvage healthcare for poor people, which is we call Medicaid. And the problem with the whole nursing home thing is that when the powers that be decided to determine which program would cover this particular expense, instead of them putting nursing home coverage into the Medicare column, which is where the old people insurance is. And really, if you think about it, most of the people in a nursing home are pretty old. The government, decided to put it into the program for poor people healthcare. I don't know why they did that. That's what happened, but that's why we have to talk about Medicaid today, because when they originally created this thing, in my opinion, they put it in the wrong program. Okay, fine. Is Medicaid for poor people? I would say no. I sometimes jokingly say that I can make Bill Gates eligible for Medicaid benefits. And technically, under the rules and under the law, I could do that. Now, Bill Gates probably doesn't need me. Why? Well, if Bill Gates has a nursing home problem, he's probably going to just build a nursing home and attach it to his house.
Yeah.
He doesn't need to be eligible for Medicaid. But the vast majority of the rest of us people out there, us normal people that have regular lives, that have worked all their lives, have a little bit of life savings, living on a fixed income, some Social Security and a pension, and now are faced with a $12,000 a month bill, we need to be on Medicaid in that situation. So in 1988, a little historical reference point, President Reagan and the Congress got together and decided to reach into the Medicaid program and change some of its eligibility requirements. And when they did this, they really made Medicaid into what I call a new middle-class entitlement for seniors. This middle-class entitlement for seniors was designed to help you pay for the cost of this care by making it easier to access the Medicaid program. And after that legislation in 1988, again, it really mutated, especially when we're talking about Medicaid in the context of nursing home care and assisted living care and home care. It really broadened the scope and the spectrum of who can qualify. You still need to qualify, though. Because it has its origin story back in this healthcare for poor people idea, you have to meet certain financial eligibility requirements for Medicaid in order to be on the program. In Florida, it's broken down into two main components, two different, I call them tests. Medicaid is basically going to look at what you get and what you've got. What you get is your income coming in. There's an income test. And then what you've got are your assets. That's stuff that you have, your bank account, your checking account, your real properties that you have, everything that you have, with the very few small exceptions of things that aren't counted. We'll go over that in a minute. But let's talk about income first. Medicaid's going to look at what you got. Now, the state of Florida is one of a group of states in the country that actually look at income as an eligibility requirement. We're called an income cap state in Florida. There are other states that are income cap states. One that comes to mind is Colorado, for example. They also look at the amount of income that you have to determine eligibility for this program. New York State doesn't look at your income. They only look at your assets. Okay. Wow, that's a big deal. When I first started practicing law and started doing Medicaid law back in 1990, I ran into this problem of how do I fix it? How do I make my client that has too much income qualify for benefits? This is a pretty steep hill, and it took a while to figure out how to fix it. I'll share with you that in just a second. Regardless, though, let's talk about this cap. Medicaid in Florida says that you have to have a certain amount of income or below in order to qualify for Medicaid benefits. Or if you're above that magic line, you're not eligible for Medicaid in the state of Florida. What is that line? This year, and it's important to note that that number changes every year. It's indexed like your Social Security. There's kind of a COLA, or a cost of living adjustment, on your Social Security every year. Likewise, on the Medicaid income cap, there is also an adjustment. It does change every year. This year now, in 2025, the income limit or cap in Florida is $2,901 of gross income, $2,901 of gross income. Gross income is an important phrase because you guys that got Social Security and a pension coming in on a monthly basis, you're not getting your gross income. You're getting a net income. That's after things have been taken out. One of the big things that's taken out of everybody's Social Security check is your Medicare Part B premium. That Part B premium, around $174, let's say, you never see that money. That's not going into your bank account. But Medicaid is going to count it as your income, even though you're not getting it, because it's this gross versus net number. So why is that important? Well, 2901 is a very magic number. You're a dollar over that, you're disqualified for Medicaid benefits. So if you are hovering around that 2901 number, maybe a $50, $60, $100 less than that, and you think that you're in good shape, you might want to check the net versus gross thing, because you have to add the 174 back in. When you do that, your gross income could go above the magic line, the income cap, and now you're disqualified. So a very, very big deal. Also important to note is that in a situation where you have this income limit and you're thinking, okay, what's counted as income? Pretty much everything. If it comes in, it's income, not complicated. However, if you're in a married situation, it's a husband and wife, a lot of my married couple clients will look at their income as their combined income, both of their income together, because that's what they're living on. That's what they have to spend. That's what they can spend for their expenses. That's not what we look at. In a married situation, you only look at the income of the person that's going to be applying for benefits. So if it's the husband, we look at his income. We don't add the wife's income into that situation. If the wife is in care, she's in the nursing home, we're looking at getting her Medicaid eligible, we don't combine his income with hers. It's only the income of the applicant that we're looking at. All right, 2901 is the magic number. If you're below that, we're good to go. Good thumbs up. What happens if we have more than that? When I first started practicing law back in 1990, and I ran into this problem. And by the way, in 1990, there was no courses on elder law. There was no books written on elder law. There wasn't anything in law school that taught you how to do this. So I kind of ran into this whole problem and had to figure a lot of things out on my own, which I guess is fun. One of the problems that I ran into was this income cap. And I thought, there's got to be a solution to this. There's got to be a solution to this problem. Bang, 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 my head against the wall, not coming up with a solution. Finally, the only thing that I could think of, really the only option, if you were in Florida and you were above the magic line, was to send you to a different state, like New York, that doesn't have an income cap. You go to New York, they don't care what your income is, but they care what it is here in Florida. So again, jokingly, I would say that I had a drawer full of maps, and if you were over income, I'd give you a map to New York, and good luck and bon voyage. Not a great solution as a lawyer. Then kind of a little miracle happened. And that miracle was there was a guy by the name of Miller in the state of Colorado. Now remember, Colorado is an income cap state just like Florida. And so Miller rolls into the Medicaid office. He's in the nursing home and he wants Medicaid in Colorado to pay for the cost of his care. He jumps through all the hoops, checks all the boxes, passes all the tests, and he gets to the income situation. And let's say for the sake of discussion today, Miller had $2,902 of gross income, $2,902. Under today's numbers, that would be $1 over the limit. Because he was over the limit, he was disqualified for Medicaid. Medicaid's not going to provide any coverage for him. And again, jokingly, I say that the Medicaid hearing officer reached down into his desk and handed Miller a map to New York. Bon voyage. Too bad, so sad. You're not going to be eligible here in Colorado. Have a nice trip. I'm making that part up, if you couldn't tell. So the idea is, though, Miller was a little mad about this, and like he should be. He's like, man, I got to go to New York. This doesn't sound like a good deal. So he hired a lawyer from Colorado Springs, of all places. And this lawyer had an epiphany, one of those light bulbs that went on over his head. And he goes, wow, this really isn't fair. And so he goes into court and he goes to the judge, Judge, this isn't fair. Now, normally when you're a lawyer and you're using the fairness argument, it's a loser. Really? Judge says to this guy, that's all you got, is it's not fair? The lawyer says, yeah, but let me tell you why. You see, the federal Constitution of the United States says if it's a federal law, it has to be equally applied to everybody. It's called the Equal Protection Clause in the Constitution. And this lawyer, when this moment of insight, says, you know, Medicaid is part federal and part state. It's not just state law. It's got federalness involved. And because of that federal aspect, it has to play by the rules of the United States federal Constitution. It ain't fair, because he's not getting treated equally if he can go to New York and get eligible, but he can't be eligible here in Colorado. Wow, unbelievable. Judge says, you're right, it's not fair, and he wins, which means Miller doesn't have to go to New York. Judge came in and said, here's what we're going to do for you, Miller. We're going to create a concept where if you take that money that you're over this cap in Colorado, that income that you're over, and you put it into this checking account at the bank, we're going to call that an income trust. If you put it into that, for every dollar you put into that magic kind of account, will be a dollar we'll subtract from what your income is. And when we subtract that income, now you can get below the cap and you don't have to go to New York and you'll be eligible in Colorado. Wow, this was unbelievably cool, because now I could throw away my maps. I didn't have to send people to New York. I could take care of them here in Florida. We were so excited about this. All the elder law attorneys in the income cap states said, look, we're going to do just what Miller does. We even named the trust after him. So we call it, or was called, a Miller Trust. So if you're ever doing any research or you're reading something and you find this word Miller Trust out there, that's the guy in Colorado who sued the state and won. Now, after that case was put into effect, the federal government came in and rewrote the federal legislation. And now we don't really call it a Miller Trust as much anymore. We might reference it, or you might see reference to that, but it's technically called a qualified income trust. We love letters in the law. We sometimes call it a QIT. When I'm talking to my clients, I just call it an income trust, because it's designed to reduce the income below the cap so we can qualify. Awesome. Not complicated how this necessarily works. Income trust is kind of like a flow chart. What happens is money is coming into the applicant's account every month. If he's at or below the income limit, he's going to qualify for benefits, at least under that test. And the way Medicaid works in this situation is he does have a responsibility to pay part of the bill at the nursing home. It's called a patient responsibility. And it's very easily calculated. Basically, all of his income minus $160 gets paid to the nursing home, and then Medicaid comes in and pays the difference. So from a cash flow perspective, he's not bleeding out. He's not having to reach into his savings or any of his other resources. He pays his income. Medicaid makes up the difference. If he makes more than the magic number, that income cap, he's not eligible until he creates this income trust. The income trust, again, nothing really more complicated than a checking account at the local bank. So instead of paying all the money to the income, all the income to the nursing home, he does have to pass some of this income through that income trust checking account. And remember, for every dollar that goes in there, we can subtract a dollar from his income. So hypothetically, if we look at Mr. Applicant with 2902, if you put $1 into that income trust every month, that's $1 that subtracts, and now he's at or below the magic number, and it's thumbs up, and we're meet the Medicaid eligibility requirements. Just to complete the process, nothing actually stays in that income trust. It's kind of like a rest area or a pit stop for this money. The money goes in the beginning of the month, and it ultimately comes out at the end of the month and goes to the nursing home. That's the income. Remember, the guy has to pay all of his income. If some of it's parked in the income trust, he's not able to do that. So in some kind of wild thing, money goes in, money goes out, and as long as it's passing through that income trust, this whole system works. Very, very cool. Setting up an income trust, not very difficult. It's basically signing a document, creating the bank account, going down to the local bank, showing them the trust, say, I need a checking account in the name of this trust. Also not very difficult. The use of it, money goes in, money goes out. There's just a flow chart, not very difficult. The only real challenge, however, that I face almost on a daily basis, actually, though, is having somebody with the ability to sign it. Signing the income trust can be signed by only a handful of different people. One person who can sign it is Mr. Applicant. He can sign his own income trust. And the unfortunate reality of this situation, he's in the nursing home. He's got dementia. He's in a coma. I mean, whatever. He's got issues that he doesn't either have the physical or mental abilities or capacity in order to sign that income trust. So that's out. Well, what happens if he's married? Under the rules, his spouse can sign this income trust for him. That can be very, very helpful, and we do that a lot. Now, what happens if he's not married? Well, if he goes to, or we go to the guardianship court and have the court declare him incompetent, jump through a bunch of hoops, and have the court appoint a guardian, then the guardian can sign that income trust as well. That guardianship process could easily take 3 months. That's bad because that's 3 months where we're not eligible for Medicaid benefits. And that's at 10 grand a month, that's $30,000 that's going out because I'm messing around in the guardianship court. The last person that can sign this is the person's power of attorney. The technical name for that guy is an attorney in fact, but we just always call the power of attorney. So the power of attorney person, they should be able to sign this income trust on the person's behalf. However, this is kind of a big deal. When we say should be able to sign it, powers of attorney in Florida are strictly construed. And that's kind of a fancy way of saying that if the piece of paper, the power of attorney document, if it doesn't say the person can do a thing, then they can't do that thing. And this gets very, very specific. First, there needs to be language inside the power of attorney that says, hey, my attorney in fact person, they have the ability to create trusts on my behalf. That has to be said correctly. For example, if the paragraph in the power of attorney said, my power of attorney person has the ability to create revocable trusts on my behalf. I see this a lot. That sounds really good, you're saying. Yeah, that sounds good, right, Sean? No, not good. Because this income trust thing that we're talking about is not a revocable or revocable trust. It is an irrevocable trust under the rules. Totally different animal. So if you have the ability to create revocable trusts under the power of attorney document, you don't have the ability to create an irrevocable trust. A huge failure point that we see, again, almost on a daily basis. To make it even more challenging for people, the state of Florida recently rewrote the power of attorney statute. When they rewrote it, which by the way, really needed to be done because the last one, the one that we had been using for decades, was really poorly drafted. So they fixed a lot of the problems with the old statute, which was fabulous. And then they might have gone too far. When they rewrote this statute, they put an affirmative requirement that you, the person signing your power of attorney, in order to grant 7 particular powers, we call these the 7 superpowers. In order to grant one of those 7 powers, you have to specifically initial the paragraph that has that particular power. Again, these superpowers, I don't know, maybe the legislatures just thought these were really big deals and make sure that you really, really wanted to do this, they were going to make you initial it. I guess there's good reasons for that, but here's the end result of having this affirmative requirement in the law, is nobody initials it. On a daily basis, I'm reviewing power of attorneys for clients. Dad's in the nursing home, son comes in, yeah, do you have a power of attorney? Sure, I have one, Sean. He hands me the document. I'm looking through it. I want to make sure that it looks good and has all the provisions in it. By the way, most don't. And then I get to the section where these superpowers are. And there's the paragraphs. And and by the way, one of the superpowers that has to be initialed, the ability to create a trust. First one on the list in the statute is the ability to create a trust. So I'm looking through it. Hey, there's the paragraphs. Oh, look, there it is. My power of attorney person has the ability to create a trust, including irrevocable income trust in order to qualify me for Medicaid benefits. Awesome. Perfect language, right? Except there's a little line next to it. And that little line is where the guy was supposed to initial it. Didn't initial it. Didn't initial any of the other 6 things. Daily, I see this happen. And it makes me so crazy because I'm thinking about this lawyer that drafted this for the client. He kind of had one job here. And when they sat down to sign the thing, didn't he go to that page and said, here, can you initial all these things, please? Really important. If you don't do this, we're not going to be able to give that a power or the authority to your backup person. You think that'd be important? Yeah, super important. Super failure point. See it all the time. Powers of attorney, don't mean to scare everybody. They're unbelievably important. In my world, I would say about 70% of the power of attorney documents that I review are fundamentally flawed, including documents, not just ones from the internet that you downloaded, but even including ones drafted by other lawyers. And these are not necessarily bad lawyers. I'll see a document come in recently from a lawyer that I really respect. He's a great lawyer in what he does, but he doesn't really do what I do. And so he did a power of attorney, pulled it out of his computer, and had the client sign it. Didn't comply with the statute, didn't have the right terms in it. It was a total fail. He's great at what he does. This is not what he should be doing. So your mileage may vary on this situation. The big idea here is let's talk about 5 most common failure points. There are 5 big things that can fail in a power of attorney, the most common. I'm in my materials that I'm going to set up for everybody that's listening today and or watching. In that will be this big 5 sheet. And when you read through that, these are the big 5 most common failure points in power of attorneys. I'm also going to give you the Super 7 list as well. It's on kind of another form for you to look at. But in these big 5 things, one of the biggest ones is the ability to create a trust and to make sure that it's initialed. Am I asking you guys to be experts on this? No. Typically, we review people's powers of attorney for free. They come into the office, I take a look at the documents, and I will tell you whether they're good or bad. I'll give them a grade on an A to an F level, and I'll tell you what's wrong or right with it, and then you can decide whether you want to fix it or not. But I give you the big 5 list in the materials so that you can at least maybe do a little bit of your own inquiry. All right, so powers of attorney, super, super important, probably the most important legal document you can have. If you don't have one, you need one yesterday. It should be newer than 5 years. If your document you did 10 years ago, you need to redo it. It needs to be fresher. That 5-year rule is pretty important. It's not hard to do and doesn't cost a lot. So big deal on the power of attorney. All right, let's shift gears. Let's talk a little bit about assets for a minute. Assets, it's the other side of the financial eligibility coin. They're looking at what you get. That was your income. Now the state of Florida is also going to look at what you've got. This is also a very, very big deal. To make things more interesting, Medicaid has 2 different numbers. These are, let's call them asset limits. If you're below the limit, again, thumbs up, you're eligible for benefits. I don't have a lot of work to do because you're at or below, and you can check that box. If you're above that magic asset limit, disqualified for Medicaid benefits because you don't meet the requirements. Now, again, to make things interesting, the state of Florida has 2 different asset limits. Why? Well, I guess there's reasons. There is an asset limit for a married person applying for Medicaid benefits, and there's also an asset limit for a single applicant or a single person not married applying for Medicaid benefits. If we look at the married couple, and let's say the husband's going into the nursing home, the state of Florida says that if you have, let's just round the numbers, $160,000 in countable assets or less, then you thumbs up, you pass the income test, you're below the asset limit, and you can check that box and you can qualify for Medicaid benefits. $160,000 in countable assets. That word countable is very, very important because as soon as I say the word countable, I'm really creating another category of assets that we'll call non-countable. So Medicaid counts some stuff, most stuff actually, but there are a couple of things that Medicaid does not count. So let's take a look at that. This is kind of a big deal. So when we're looking at $160,000, for example, Medicaid is not counting the value of your home. Your home is not counted as an asset. So let's say you have a $300,000 home. It's paid off. Awesome. Great, no mortgage payment, congratulations. Is Medicaid going to count that home as part of your assets? Again, the answer is no. It has effectively a zero value for purposes of eligibility. Zero. Not counted. That's really good. Also, you're allowed to have one car newer than 7 years. Basically, any cars, I would say unlimited. The statutes don't say exactly how many, but they don't count cars that are older than 7 years. And they don't count one car newer than 7 years. So let's set this up. So I have a husband and wife situation. They have $160,000 in the bank. They own a $300,000 house free and clear, and they have a brand new Ford F-150 truck in the garage that's worth $50,000. Do they pass the asset test? Yeah. At or below 160, cool. House isn't counted, zero. One brand new 150 in the garage, also not counted because that has a zero value as well. So countable versus non-countable, kind of an important point. If you're single, the numbers change just a little bit. The asset eligibility number for a single person applying for Medicaid benefits is $2,000, not $160, but $2,000. So there's a little difference. And what does this mean in real world terms? Well, if you kind of roll into my office and you're a married couple, there's at least a reasonable chance and expectation that you're below this asset cap and you're good to go as far as assets are concerned for eligibility. It's a reasonable expectation. It's definitely possible. If you're a single person applying for Medicaid benefits, the reality is pretty darn sure in the vast majority of cases, you're not going to be eligible at the outset because you're going to have more than $2,000. Just a fact. Now, every now and then I have a client that doesn't. I had one this week, actually. Lady's down in LaBelle, Florida. Her daughter is actually up in New York, and I'm going to qualify her for Medicaid benefits. She has about a $300,000 home. I don't think she has a car, and she has a very small bank account that has around $2,000. So she pretty much checks that box. Her income, however, is about $3,400 a month. So we're going to have to fix that with an income trust. But by the end of May, we'll be eligible for Medicaid benefits. So that's really cool. If, however, she was like most people, she would have more than $2,000. And that's where somebody like me comes into play to fix that problem. Now, fixing that problem can be a little bit of a challenge, but I have been doing this for 35 years or so. And I would say I've had more than 10,000 Medicaid cases in the course of that time. And there's never been a case that we have not been able to fix. So this is very much a fixable problem. You have to know what the problem is before you start to fix it. So regardless, if you are a married situation or a single situation, you're above whatever your magic number is, either the 160 or the 2, that is a fixable problem. And this is where we come in and we have to do some work. So the way we do it is we'll do an analysis of the person's financial situation. Got to get a lot of data, a lot of information. Well, who are you? How old are you? What's your family structure look like? What's your monthly income from all your different sources? Have you given anything away? We'll talk about that in a second. That's a big deal. Do you own a home? Do you own any other real property that's out there? Do you have rentals, for example, or a vacation house, or who knows? Do you have property that you're renting as a business or whatever that you own? So I want to get all that data. And then I want to look at, well, what are your bank accounts? What's your savings? What's your checking account? Do you have a money market account? What about any 401ks or any IRAs that are out there? Do you have an annuity? I need to see basically everything that you own because Medicaid is going to look at that as well. So we do this assessment. I actually, in my practice, I create a spreadsheet where I take all of your stuff and all your incomes and all of your different assets, and I put it all in a spreadsheet. It adds it all up for us, and we can say, here, listen, here's the problems. Too much here, income's good, whatever. And then we can identify those problems and start fixing them. Very cool. So how do you fix this, Sean? How do you move all this assets? I mean, how do you make this magic happen? That is an amazingly good question. And we have about 25 more minutes to tell you how to be an elder law attorney. I'm not sure I can do that. Okay, I'm pretty good at what I do, but I don't think I can make you guys into elder law attorneys in the next 25 minutes. Suffice it to say that all of my clients have one thing in common. And the one thing that they have in common is that they are all different. And because of that difference from one client to the next, means that every solution that we use to solve this problem is custom tailored for their particular set of facts. How old they are, how sick they are, what the diseases that we're dealing with, a Parkinson's patient versus an Alzheimer's patient versus a stroke patient versus this, all of those have different effects. Do you have IRAs? Do you not have IRAs? How much money do you have? Is there a capital gain issue with these monies if we're going to cash them in and move them? So lots and lots of factors that come into play to decide exactly what to do to fix the problem. There is always a solution though. So what do you do, Sean, to fix this? Well, if I were to break it down into like two broad categories of different kind of techniques, and kind of at the very, very top level, one technique, one kind of area is the movement or the change, excuse me, of the asset's characteristics. Changing the characteristics of the asset so that it's not counted as an asset any longer. And then the other kind of category of strategies, if we look at just the kind of be overly simplistic, is the issue of, how should I say this? Moving the asset. So when you move the asset, you got to be very careful on how you do that. Moving an asset, transferring an asset, giving an asset away is bad. Why is it bad? Because in the Medicaid Bible, there is one commandment, the first commandment. And that commandment is, thou shalt not give your assets away to qualify for Medicaid. If you give your assets away, what happens is you're disqualified. The penalty for giving your stuff away is disqualification. And if you think about it for just a half a second, you say, okay, Sean, you told me I have this asset limit. Okay, good. I just did the math and I'm $10,000 over where I need to be. I got $10,000 too much. Okay. And I'm going to the nursing home. In order to qualify for Medicaid, apparently I can't have that $10,000. So I'm just going to write a check to my son. Hand him the check. Awesome. He now cashes the check, puts that money in his bank account. You don't have that money any longer. You're at or below the asset limit because you gave the money to your son. We're good, right? Eligible for benefits, right? Nope. Because you violated that commandment, that rule. You gave something away, and giving something away is a problem. Why? They disqualify you for it. So when you go through the application process for Medicaid benefits, what you basically, one of the questions that you have to do is that, or have to answer, is that Medicaid is going to ask you, have you sold, transferred, or given anything away in the last 5 years? 5 years, 60 months, same period of time. They often refer to this as the 5-year rule. There's a lot of misinformation out there about what this actually is. If you've heard anything about Medicaid, you've probably heard something about 5 years. What is that? Well, most people think that the 5-year issue is that if I didn't do something about this problem 5 years in advance, I'm kind of screwed and I can't qualify for Medicaid benefits. And lo and behold, I didn't do that. So I'm not even going to bother applying. Medicaid's out. That is not what the 5-year rule is. The 5-year rule is technically referred to or known as a look-back period. A look-back period. And what that means is that Medicaid is looking back 5 years from the date of your application to see if you gave any of your stuff away. If you have, then you're disqualified for benefits. If you gave something away, hypothetically, $1 million, 61 months ago, that's 5 years and a month ago, Medicaid doesn't care about it and it doesn't hurt you. But if you gave it away 59 months ago, you got a problem. So that's what this is. This look back period is really a disclosure period that you have to disclose if you gave any assets away. Well, do I have to tell them, Sean? Well, yeah, you kind of do. Well, how are they going to know? Well, they're going to ask you, and you need to tell them the truth. Failure to tell them the truth is where you start getting into the criminal world. It's a felony to apply and use fraud to qualify for Medicaid benefits. And when you don't tell them about that transfer, that's fraud, that's a felony, that's a crime, okay? So let's not create a crime. but you do have to tell them about it. Well, are we screwed? Are we out of the, are we done? Do I have to wait another 4 years in order to get this thing to fall off the table? I mean, what do we do? Is there a solution to this problem? And the answer is yes. So one of my favorite things to say is that any problem with a solution isn't really a problem. So giving your assets away, initially an issue, for sure disqualifies you for Medicaid benefits. Giving assets away within that 60-month, 5-year period, definitely a bad thing. Can we fix it? And the answer is yes, we can. It's a pretty cool fix. Not that complicated, actually. So Medicaid says you can't give anything away, but you can fix this by doing what we call a retransfer. And now what a retransfer is that you basically give the money back. So instead of the money just going out, if it comes back, the gift never happened. The transfer never happened. So there's an analogy I use for this, and it's a chess analogy. Don't everybody stop listening when I say the word chess. It's not that complicated of a concept. In the game of chess, there's rules, and you can move pieces only according to what the rules say. So there's a piece called a bishop. A bishop can only move diagonally. If you're playing chess and you move it horizontally or vertically, then what happens in that situation, that's an illegal move. And before you can play the game, you have to correct your illegal move, bring the piece back to where it started from, and then move it according to what the rules say. So a transfer is you've moved your piece the wrong way. In order to fix this problem, we got to bring it back to the starting point, undo it, retransfer, have the money given back. And then we can move that money. I use the word reposition those funds under what Medicaid's rules allow you to do so that we play by the rules and we don't get into trouble. So retransferring, very, very important. Good way of fixing problems. Little footnote here. If you're currently dealing with an issue, a caregiving situation, you have this problem kind of manifesting in your world right now. Hypothetically, you're dealing with Alzheimer's, for example, or dealing with your spouse. He's had a diagnosis for the last 2 years. He's still at home, but we know where this train is going to take us eventually. If you run into that situation, for goodness sake, please don't be giving your stuff away, because now you're just digging a hole of disqualification that I have to come back and fix. And I can fix it, but I'd rather you not break the rule first or violate the rule first. So be very careful. If you are in a situation where you're a caregiver, this thing is manifesting in your world, we know that Medicaid is definitely on your horizon. We're going to need to have care, home, assisted living, or nursing home, and you need to give an asset away for whatever reason. This actually happens more often than you might think. You need to see somebody like me, because I can put a strategy in place where I can move those funds in a way where Medicaid will not disqualify you. Well, they will not look at it as a disqualifying transfer. And again, easier to fix the problem before you make it than it is to fix it after you've made it. All right, so this retransfer thing, Sean, sounds pretty cool. All right, great. Well, what happens if the person I gave the money to doesn't have the money any longer? Good question. So, real story. I had a lady, beautiful, wonderful woman up in Inverness, Florida. She was taking care of her husband who had Alzheimer's disease, and she was 90, 91, and she had pretty much ran out of steam. His needs for care and her abilities had definitely parted ways. She couldn't take care of him any longer, so she placed him in a nursing home. And she comes to me to get him eligible for Medicaid to pay for the bill. So we're doing our kind of initial interview process. And one of the questions that I have always is like, hey, well, did you give anything away in the last 5 years? And she says, well, Sean, about 3 years ago, my daughter was going through a divorce and I gave her $36,000 to buy a new car. Great. Not great, because the gift of that $36,000 to her daughter disqualifies her husband for Medicaid benefits. It's not just his transfers in a husband and wife situation. It's also hers, by the way. They're kind of treated together as the same person. So I go, that's going to be a problem. And so I asked her, and this is just vivid memory of how this is actually kind of funny, as I said, well, can your daughter give the money back? And the 91-year-old lady looks at me and says, well, Sean, you were listening, right? Yeah. Well, she bought a car with it. Oh, so she doesn't have it. Okay, well, that's a problem. And I go, well, can somebody else give it back to you? It doesn't have to come back from the person you gave it to. And she says, and this is a true story, she goes, well, could my neighbor do that? Okay, I wasn't expecting her to say that. So it's like, yeah, I don't care who the money is coming back from. So the next day, the neighbor came into the office and wrote a check to my client for $36,000. Client put that money into her bank account, and we just erased the problem, made the transfer not happen. We undid it. We retransferred it. The whole issue of giving the money away now became a non-issue. Cool. So we solved one problem, but we created a new problem because now my client has $36,000 more in assets and her neighbor does not. So the following day, after the money went back to my client, we moved the money from my client back to the neighbor in a way that Medicaid was not mad about. So by the end of the week, we had undone the transfer. We had moved the money into my client's name. Then we moved it back to the neighbor's name, and we were good to go and solve the problem. The world of Medicaid is incredibly wild. I mean, it's from a legal perspective, from a logical perspective, there's very little logic in it. Sometimes I've referred to it as Alice in Wonderland law. Alice in Wonderland, nothing really makes sense. Big is small, up is down. One thing does not follow the other, and it can be a little crazy. That's a good example of the craziness. So again, giving things away can be very, very bad. Don't do it. If you have to do it, make sure you see somebody like me that can help you do it in a way where they won't be disqualified. All right, what else do we need to know about Medicaid? So we've talked about a couple of things right now. We've talked about asset eligibility, talked about income eligibility. Income is solved with the income trust typically. Assets, we need to fix that problem if we're over assets. There is two broad categories to fixing that problem. One is moving the assets in a way that Medicaid's not mad about, being very careful not to move the assets in a way where they will be mad, which means violating the rules. And then there's another option, which is changing the characteristics of the assets. Changing the characteristic, basically shifting it from being counted to not being counted. Lots of different ways of doing this as well, but I want to share with you one particular, very specific example, just to give you some insight into how this can conceptually work. One of my favorite assets when coming in a situation with a client and I'm fixing their situation, qualifying them for Medicaid. One of my favorite assets is a tax qualified investment. And what that means in my world, a tax qualified investment is like an IRA or a 401k, some type of investment that you've never paid any income tax on until you take it out. So traditionally with an IRA, you've put all this money in over your working life. It's been there. You've never paid income taxes on the money that you put in there. But when you take the money out, that's a taxable distribution, which means you got to count it like regular income and pay taxes on it on April 15th. If you're over, I think, 73 now, they keep on moving the bar. You do have a required minimum distribution that you have to take every year based upon how much money you have in that investment and how old you are. It's an RMD, or a required minimum distribution. When that RMD comes out, you're paying income tax on that distribution. However, the underlying money in that IRA is counted as an asset for purposes of your eligibility. So if you got 30 grand in your IRA, that's $30,000 that is counted against you. If you are a single person and your magic number is 2,000, that 30 is putting you over the limit. IRAs are kind of annoying in some ways, because if I was going to take that IRA and move it in a way that Medicaid's okay with, I'd have to first cash it out and take a distribution of that IRA, a full distribution. If it's 30 grand, I got to take 30 grand out of your IRA. When we take that $30,000 out, that's income. And we got to pay income taxes on that 30,000 bucks, which can be very annoying to say the least. So do we have to do that? And in this particular strategy, you do not. Now, I call this strategy, and I'm the only person that calls it this. You can't go to some other lawyer and say, what about this strategy that Sean was talking about? I call it the David Copperfield strategy. And I call it the David Copperfield strategy because it's kind of like David Copperfield. You might have heard of this guy. He does these, I actually saw him in Tampa at the Performing Arts Center. Blew my mind. Unbelievably cool. But he's definitely not a magician. Got to say that word right. He's definitely not a magician. If you ask him, are you a magician? He'll say, no, I'm an illusionist. What's the difference? Well, a magician actually makes something disappear. An illusionist makes something appear to disappear. So I call this particular strategy the David Copperfield strategy. And it has to do with IRAs. I can make that IRA appear to disappear, but not go anywhere, not have to be pulled out, not to have any income taxes paid on it. But on Monday, it's counted as an asset. We do our magic on Tuesday, and on Wednesday, Medicaid says it has a zero value. But it's still there. It's just appeared to disappear. Interesting enough, historically, I kind of learned this technique or strategy from Medicaid, from the Department of Children and Families. Very early on in my career, I was having a hearing on a case, sitting in front of the hearings officer, and we're discussing the parameters of the case. And she says to me, well, Sean, you know, I'm like, you can do what? Well, yeah, if you do this with the IRA, then we won't count it. I can't? Remember, no books out there on this, so you learn as you go in some ways. And since then, I've been using this strategy. And basically what we do in order to fix this particular problem with this particular asset, excuse me, is that we are going to change its characteristics so that the IRA appears or looks like a pension plan. Now, under the rules, under the Medicaid rules, a pension plan is not counted as an asset. That's very good. Initially, the IRA or the 401k is counted, but we come in and we tweak some of its characteristics. And those tweaks specifically have to do with taking out a periodic, automatic, and regular distribution out of that IRA, a monthly distribution. When we run the formulas, we look at how old the person is, how much the money is, all of these characteristics, we can come up with a number, and then we can make a monthly distribution for that number. And as soon as we turn it on, in other words, make this monthly distribution start happening, the value of the IRA is set to zero for eligibility purposes. Very, very cool, very easy. And I've saved hundreds of thousands of dollars for clients that have this problem, and we've done it basically within a couple of days. Very, very cool. All right, gone over a lot of information for you today, for sure. We've talked about asset numbers, income numbers, can't give things away, solutions to these problems, the importance of a power of attorney, for example, and how incredibly important that is. Just 1 or 2 minutes on estate planning, just to make a very important point. One of the most common overlooked issues when doing this whole Medicaid thing is the estate plan of the healthy spouse. Husband's going into the nursing home. He's sucking up all the oxygen in the room. He's kind of the star of the show. Focus is all on him. We move all these assets. We take care of the income. We place him. We go jump through the application process for Medicaid eligibility, and he's on Medicaid. Awesome. 160 grand, let's say, for the sake of discussion, is sitting in the wife's name. Great. On the way to the nursing home, wife's driving over to see her husband. He's on Medicaid now. She's feeling really good about things. She's not going to be wiped out by the cost of care. Everything's looking pretty good. He's getting taken care of. She's not under the burden any longer. Everything's coming up roses. And then a big garbage truck creams her in her car, and she doesn't make it out of the accident. And she's now dead. Ironically, on the way to see her husband at the nursing home. She's dead. What's her estate plan say? Typical situation when we have a husband and wife scenario. Think about it if you're a married person. We have what's known as a reciprocal I love you estate plan, which is like, baby, I love you so much. If I die first, well, I want you to get everything, says the husband. And the wife says, well, honey bunny, if I die first, I want you to get everything. So it's this reciprocal back and forth kind of thing. Super standard, very, very traditional. See it all the time. So she's rolling into the nursing home that day with that will that says if she dies first, everything goes to him. And lo and behold, bam, she gets killed. Where does all her stuff go? To him. Is he married anymore? No, he's now a single person. What's that mean? $2,000 asset limit. Everything gets dumped back into his lap. He's over $2,000. He was on Medicaid. Now, because of her dying at the wrong time, boom, his eligibility has been destroyed, and he's back on private pay, writing a $12,000 check to the nursing home every month. There is a very good possibility that the healthy spouse could die before the person that she's taking care of. Statistically, it's about a 67% greater chance of dying than the person she's taking care of. So the odds are not even in her favor, let alone talking about the garbage truck, okay? So you must, in a husband and wife scenario, address the estate plan of the healthier spouse. We don't change it when you get to the nursing home, by the way. If you're a wife and you're taking care of your husband, for example, and he has a diagnosis of Alzheimer's disease, one of the things that you should already have done is change your estate plan. That if you die first, the money doesn't go directly to him. We can keep him inherited, we can take care of him, but we have to do it in a way where he's not going to directly receive that money. Very, very important. Okay, so we're getting ready to round up. I think we are going to make some things available to everybody that's listening today. It's going to be a little tricky on how we do this. I'm going to give you the Big Five, the Super 7 situation. I'm also going to give you one of our brochures that we hand out to prospective clients that really gives a good summary of what Medicaid is all about. It's about 20 pages long. It's a pretty good summary, pretty in-depth. And then to go a little bit deeper, anybody that's listening today or watching today, we're going to give you a copy of my book, the Medicaid Handbook. It's a book I wrote. It's about 160, 170 pages, pretty extensive, written in a real plain English kind of way. So it's not like overly, oh my gosh, all these big words. I don't really like big words. I like simple English. So what we're going to do is we're going to give you a link to a Google Drive, which is basically a link on the web that you can go on your computer or your iPad or your tablet and download all of this stuff. It's a little tricky. And in order to get to that link, there's a thing called a QR code. So what we're going to put up here is a QR code that you can take a picture or use your phone camera, and that will automatically give you the link. So instead of writing all of these letters down and all these slashes and all of that, if you take a picture or use your phone, you can scan that code and it'll bring you right to the drive and you can download all these materials. And hopefully that's easy for you.
I
Now, I
just
know
did
not
it.
everybody's
I
super
just
tech
did it,
savvy.
Sean. I just
Do
did
what?
it. I just did it. It's all right
Oh,
here. It's perfect.
excellent. Great. See how easy that was, Linda?
Yeah,
Excellent.
if I
So
can do it, anybody can do it.
if Linda can do it, anybody can do it. And Linda, don't take this the wrong way. I'm doing webinars now because of you, because if Linda can do it, Sean Scott should be able to figure it out.
Yeah.
So anyways, if that link doesn't work or you can't figure it out for whatever reason, go to our website at flmedicaid.com. It's super easy, FL like Florida, flmedicaid.com. And flmedicaid.com, there's a link on there. Email us, send us, say, hey, can I get those materials? Can I get that link? And we'll email you the link, and that way you get the book for free.
Perfect.
If you don't want to get the book for free, you can always go on Amazon and you can download it or you can buy it. It's 20 bucks, but why not get it for free?
Exactly.
So thank you everybody for listening to me today. I hope I leave you in a different place, a little bit more enlightened, that the whole mystery of Medicaid is made better. And Linda, thank you again for letting us be here today. It's always a joy. So
thank you, my friend. Have a delicious day and we'll talk soon.
all right. Have a good day. Bye, everybody.
Thanks. I'll tell you, every single time I listen to Sean, I learn something new. Every single time I learn something new. Because you know what it is? He's so on top of everything. And when things change, he knows what changes. Then he lets me know and I can let my caregivers know.